Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
Who's for the appellant?
I'm for the appellant, Your Lordship.
Yes.
Your Lordship, this application...
In view of the good ground shown, the delay of about 8 days in preferring the appeal is condoned and the appeal is taken on board. Paragraph, proceed with the appeal.
Your Lordship, one small humble submission.
Why?
Your Lordship, today...
We don't even ask questions on limitation. You must be ready to proceed with the matter, madam.
Yes, Your Lordship. Your Lordship, the conducting counsel is Mr. B. Pan.
We don't care. We really don't care. No order. Since the would-be appellant is not prepared to proceed with the main matter, comma, let the application for condonation come 4 months hence. We are not joking around over here.
Your Lordship, I was on the limited instruction to condone.
Thank you. Call on the next matter, please.
From the main list, item number 1.
My Lord, I am appearing in the matter, my Lord.
Yes.
My Lord, this is the matter relating to the fixation of the special rate under the Excise Act, my Lord. In view of the notification issued under the Central Excise Act, my Lord.
Yes.
My Lord, there was a notification, as your Lordship is aware, that granting the full exemption from the excise duty, my Lord. Subsequently, the said was, my Lord, modified, and it was made limited to the, my Lord, only to the value addition portion. Now, in the said notification also, there was a provision for fixation of the special rate in case the value addition which has been provided for in the notification is found to be less by the SSA. Now, that said notification was a subject matter of challenge before the Guwahati High Court, and the said notification was set aside and quashed by the learned single judge in 2014 itself. Melody matter was carried in appeal, and even in appeal, Melody, the appeal of the central government was dismissed, and the single judge order was appealed. Now, against the state order, Milord, an SLP was preferred by the Union of India before the Apex Court, and the Apex Court directed, Milord, that the judgment of the division bench of the High Court shall remain, operation of the judgment of the High Court shall remain stayed, subject to the Central Union of India depositing 50% of the entitlement which was there of the SSS. Now, Milord, in 2021, the matter finally came up before the Apex Court, and the Apex Court, Milord, reversed the judgment of the division bench of the High Court and upheld the notification which was issued by the excise authorities. Now, Milord, the fixation of the special date which was there by way of the notification which was there, that was earlier set aside and quashed by the single judge, and thereafter, my lord, by the division bench of the High Court upheld it, and the Apex Court also only, my lord, observed that the operation of the judgment of the High Court shall remain stayed, subject to the payment of the 50%. Now that notification again came into operation only when the SLP was allowed, appeal was allowed, and the notifications were upheld, my lord. At that time, only the question of the filing of the application for the special date, my lord, was again revived. Now, at that time, my lord, your lordship is aware that the Shumoto order of the Apex Court was there because of the COVID-19, and because of that, my lord, the Apex Court directed that all limitations shall remain extended. Now, the petitioner filed the applications, my lord, in 2021 itself. My lord, the date I will give, my lord, your lordship. My lord, that was filed on 8/6/2021 before the fixation of the special date. Now, that applications have been rejected on the ground, my lord, that were not filed in the year 2014, because the period of the filing of the, as per the notification, 2014 up to the 1 year of the 1 month of the financial year, my lord, the application has been filed. Now, the question of filing of that application did not arise, my lord, because at that time, those notifications were set aside and quashed, and only were revived after the judgment of the Apex Court. And after that stage only, my lord, the question of filing of the special date application, my lord, again was conferred on the SSS. Now, similar matters were decided by the, my lord, in your lordship also has decided the issue. But in that case, only difference was that, my lord, in Shillong, that a writ petition was filed, and the department, my lord, gave an undertaking that the special date application will be decided, and that was rejected. And your lordship held, my lord, that since there was an undertaking given by the department to decide the special date, and thereby now they cannot again say that the special date will not be decided. But subsequently, my lord, in Guwahati High Court, number of cases, my lord, came up for fixation of the special date, and in all the cases, my lord, the taking into consideration all the facts, and including the order of the Apex Court in the Shumoto, my lord, this Guwahati High Court directed the department to process the application and to decide the special date on, my lord, merit. I forwarded, my lord, the copy of the judgments of the, my lord, the Guwahati High Court before your lordship, my lord, by mail yesterday. If your lordship has got it, my lord. On WPC 740 of 2022.
Paragraph 33.
My lord. Now, following this, my lord, all the applications, my lord, have been allowed by the High Court, my lord, and all the applications are being decided on merits by the department. Now, my lord, once the excise department, whether it is in the Guwahati or whether, my lord, the Meghalaya, once that in one place, my lord, the special applications are being decided on merit.
Just a second.
My lord.
So, Mr. Dr. Modika, the same order, there will be a level of uniformity
My lord.
unless you have, carried a special leave petition or something against this order. This order is. This
My
order
lord, this
is.
has not been carried. Single judge, my lord. This has not been carried in appeal also, and they have accepted it, my lord.
13th of May 2022. There is no appeal.
My lord.
You take instructions.
There is no.
Take instruction on this.
Yes, let him take instructions, Dr. Sarav.
This is the order of the learned
My
single.
lord.
Yeah, order of the single judge. If you haven't appealed against it, then it's become, and there is also a principle of issue estoppel as far as you're concerned. You're an all India body.
On law, my lord, maybe, my lord, on facts, but in the present
It
case,
is
my
on
lord,
facts. It's not a legal question. Legal question is answer is in your favor because ultimately the Supreme Court has set aside the order of the Guwahati High Court.
My lord.
So therefore, now what happens during the period when the stay is there? The classical way of seeing it is that the order remains in suspended animation.
yes, my lord.
Well, I've also given the judgment on 1992 3 SCC.
Not necessary, sir. Not necessary. If your judge does not know, then throw judgments at him.
No, my lord, I'm just.
So, and the authority in this point you'd find in 99 and 91 Supreme Court. That's some
1992.
scooter company. I forget the name. Some scooter company is where you find the discussion on this. It isn't wiped out,
It is in
but it remains suspended animation.
My lord.
And sometimes a practical point of view has to be taken when it is ultimately set aside,
My lord.
because it isn't as if mere stay revives the notification. Mere stay revives certain obligations. If it is an unconditional stay, it revives certain obligations, but it does not wipe the order out altogether. So there's a fine distinction, on that. I think it's Chikmaglur something. There's a huge discussion on that. But so therefore the law is in your favor. Once the issue has been decided as to in such circumstances when similarly placed persons have been conferred a benefit which you have accepted,
My lord.
then that becomes binding on you. Because you're an all India body and there is a level of uniformity that we try. Similarly placed persons will be treated similarly. That goes in tune with Article 14, and therefore we will try and ensure that this is done. Of course, if there's a different view, or if from somewhere you've carried it up to the Supreme Court, or then we'll look at it. But I think this should be a reasonable
My
position.
factual scenario only to the extent, my lord, that under that notification they're required to do certain things within 30 days of 2014, my lord.
Yes,
Though
but that was by the legal fiction.
Till 2020, my lord.
By the legal fiction, it was not there till ultimately it was set aside by the Supreme Court.
Well, it was set aside by the Honorable Supreme Court in 2020, my lord.
It was set aside in 2020.
Even thereafter, they took several months. my lord.
2020 when? After 25th March 2020?
It is April, my lord.
April 2020? By then, the Supreme Court order had come on COVID.
My lord.
Everything would remain suspended, which order was repeated again in February of 2021.
My lord. That
Continued
period,
it for 6 months or something like that. Effectively, it remained in operation till about October 2021.
my lord.
Within reasonable time thereafter, this has been issued, and therefore, whatever may have been the special value,
My lord.
at the relevant time you compute, and then if there is a question of interest or whatever, because those guidelines are not there.
On interest.
Those guidelines are not there in the Assam order, in the Guwahati order. Guwahati order requires only for you to ascertain the special value.
To disregard the limitation, my lord, and to decide the application on merit, my lord.
On merits. So you will do that, and whatever your claim is, there will be a further round of litigation on quantum. The matter will not end over here. This is the principle for you doing it within certain parameters where limitation will be disregarded, why they failed before, all this will become irrelevant. And then when you come to quantum, the basis for arriving at the quantum, that will be subject matter of future challenge. Yes, Dr. Saraf.
Well, if your lordship just look into page 39, 37
39
of the 37 judgment, of the High Court, Guwahati High Court,
37 of the judgment.
my lord.
Yes, sir.
In the middle, my lord, it was mentioned that, as you also it was mentioned.
That wherever the timelines for extension were extended by the Supreme Court, same would apply.
No, that was circular by the Excise Department, my lord. GST policy wing has issued a circular whereby clarifications were issued regarding extension of the limitation of the GST law in terms of a Supreme Court order. In the state circular, reference was also made to the 43rd meeting of GST Council, where recommendations were made that whenever timeline extension has been made by the Supreme Court, the same would apply for the GST also. So, there is a circular also by the GST that wherever the time extension is there by the Supreme Court, that will also apply to the GST extensions also.
Yes, we've noticed that they'll take everything into consideration. This is preliminary. First, let Dr. Modika take instructions whether he will accept this. If he accepts this, it's without shedding blood, the matter is over. If we contest, then we'll go into we've indicated the pitfalls of contest because this should become binding on him.
Right.
In fact, after this, they have determined the special rate in the cases and they've already decided the
Very
department by
very
it.
The matter pertains to the benefit that the writ petitioner enjoyed prior to publication of a notification dated June 10, 2008,
27th March 2008.
March 27, 2008, prior to the publication of a notification dated March 27, 2008. Full stop. Benefit of excise exemption. Paragraph. The notification of March 27, 2008 was challenged in several courts, was challenged before the Guwahati High Court, and such challenge succeeded both before the single bench and the division bench of such High Court. A petition for special leave to appeal was carried to the Supreme Court by the department, wherein an initial order stayed the operation of the Guwahati High Court order subject to a certain deposit being made by the department, full stop. Ultimately, by a judgment and order of April
20th April.
20,
22nd.
April 20,
22nd.
April 22, 2021, the Guwahati judgments were set aside and the notification dated March 27, 2008 found to be valid. Full stop. Paragraph. In terms of the relevant notification, if the quantum of, if the extent of value addition by any SSE was in excess of the quantum arrived at by the formula indicated, a special application in such regard could be made within a specified time for the additional value addition to be claimed. Full stop. However, the key to the matter was the filing of the application with particulars in support thereof within the specified time period. Paragraph. As a consequence of the notification of March 27, 2008 being set aside by the single bench of the High Court and such order being upheld in appeal, SSCs similarly placed SSCs as the writ petitioners in the Guwahati High Court took no steps in terms of the notification of March 27, 2008, full stop. The final order of the Guwahati High Court was stayed by the Supreme Court, the legal position has to be seen as if the final order of the Guwahati High Court was in suspended animation, full stop, till such time that such order was set aside or annulled, the existence of the order could not be doubted, full stop. The issue was ultimately decided on April 22, 2021, semicolon, but, by then, the time had passed for appropriate applications being made for several years for the additional value addition that the SSCs could have claimed in the respective years. Full stop. Paragraph. Upon the department rejecting the applications made by the SSCs for additional value addition, primarily on the ground that such applications were not made within the time specified in the notification of March 27, 2008, and relying on the underlying principle that when a benefit is conferred, such benefit has to be availed in accordance with the conditions stipulated therefore, the relevant orders of the department were assailed again before the Guwahati High Court. Full stop. Paragraph. A single bench of the Guwahati High Court, in WP bracket C stroke 740 of 2022 bracket Northeast High Tech versus the Union of India bracket closed, how does the sentence go? By a judgment and order dated May 13. Just now. Decided the issues involved in a judgment and order pronounced on May 13, 2022. Full stop. The judgment noticed inter alia the impossibility on the part of SSCs apply in terms of the notification of March 27, 2008, at a time when the same had been set aside by the Guwahati High Court as, notwithstanding the stay of the operation of the Guwahati order, the legal effect of the order, initial order passed by the Supreme Court, could not be seen to be the complete resurrection and effective application of the impugned notification. Full stop. The validity of the notification was finally decided on April 22, 2021, by which time the relevant SSEs had lost out on making applications for additional value addition in terms of the said notification. Full stop. Paragraph. The judgment also noticed the orders passed by the Supreme Court suspending the operation of limitation during the COVID pandemic and the adoption of the same principle by the GST authorities, Goods and Services Tax authorities. Full stop. It is in such circumstances that the Guwahati High Court made the following order at paragraph 33. Set out paragraph 33. Paragraph. On behalf of the writ petitioner herein, it is submitted that the department has accepted the order dated May 13, 2022, passed by the single bench of the Guwahati High Court, and has even computed the quantum of additional valuation as claimed by the SSEs covered by the order and who had applied for the same. Full stop. According to the writ petitioner, the department did not prefer an appeal to the division bench of the Guwahati High Court and, as such, the order has become binding on it. Full stop. Paragraph. The underlying suggestion of the writ petitioner is that since the writ petitioner here is similarly placed as the writ petitioner in whose matter the order dated May 13, 2022 was passed, the department cannot take a different stand, particularly as the department that did not avail of the opportunity to prefer an appeal against the relevant order or carry this or challenge the same before the Supreme Court. Full stop. Paragraph. There is substantial merit in the writ petitioner's case that since the manner in which the department would deal with similarly placed SSEs as the writ petitioner in this case and the writ petitioner In the Guwahati matter covered by the order dated May 13, 2022, what does the sentence go? Right, the last in the end to at the end, comma, ought to be governed by the treatment meted out to the Guwahati petitioner by the department, full stop, paragraph. Learned additional Deputy Solicitor General, comma, appearing for the department, comma, seeks time to obtain instructions as to whether full stop, paragraph, let the matter appear a fortnight hence. So we've covered the entire gamut for you to.
It's almost a judgment.
Well, the only thing is the actual judgment is of 2020 below instead of 2021.
Sorry? Yes, the Supreme Court judgment is 2020. April 22, 2020, not 21. Yes, twice I made the mistake, I realize. Yes.
No, I'm highly obliged. No?
See, your Advocate General is also laughing at you.
Item number 3.
May it please your Lordship.
Yes.
This matter was adjourned sine die, awaiting the judgment of the Honorable Supreme Court, as the issue has been referred to 9 judges bench in this matter, my lord.
So it's
And
still
the Lordship
not,
has taken note of
it's still
the
not
fact-
been resolved.
Yes, Lordship.
That bench has not resolved it yet.
Yet not,
Very well.
it has not been resolved.
The matter was last adjourned on October 21, 2022. Since the legal question involved therein was pending consideration before a 9-judge bench of the Supreme Court. Paragraph, Learned Advocate General reports that the matter before the Supreme Court bench has not been disposed of yet. Paragraph, let this matter appear 3 months hence, with liberty to the parties to mention earlier, comma, if the Supreme Court matter is disposed of by then. Give it a date after 3 months.
Obliged.
What is wrong, Mr. Shinugupta? Don't wait, go.
Asthma.
Asthma, yeah.
After taking asthma medicine, it has an effect on gastric also. And I find it difficult for digestion, walking. Papaya.